Good morning, sir. What's your name?
Nicholas, James Nicholas.
Ms. Donnelly, do you need to speak to him? You're muted. Ms. Donnelly, can you hear me? Maybe she can't hear me. Can you hear us, Ms. Donnelly? You're representing him as well, Mr. Mills?
Yes, Your Honor.
Okay, and you don't need to speak to him, do you?
No, Your Honor.
Okay, and who do you have with you?
Zachary Johnson.
Your Honor, I'm sorry. There's something wrong with my earbuds. I can hear you now.
Okay, excellent. I just wanted to know if you need to speak to Mr. Nicholas.
Can I, Your Honor? Yes.
Yes, give me just a moment. I'll put you in a breakout room.
Thank you.
Let's see. Was a plea for Mr. Johnson?
That's correct, Your Honor. Mr. Abbott is currently down at Buchanan's right now.
Oh, okay, so we'll wait for him to be ready. And then Jessica Speck? Okay, and you're represented by Mr. Meltz? We're on the record in the matter of the people of the state of Michigan versus Jessica Lynn Speck, file number 22-03486 FY, council appearance.
Brian Reagan on behalf of the people practicing under Michigan Code 8.120. Yeah, sorry. Good morning, Your Honor. Stephen Milks on behalf of Ms. Speck, who is present and standing to my right at this time.
Okay, how are you, Ms. Speck?
I'm good. How are you?
I'm doing well. Today's the date and time set for your preliminary examination. My understanding is that there's going to be a 21-day waiver of the timeline. Is that correct, counsel?
Yes, Your Honor, that is a correct statement.
Why is that?
Your Honor, Melanie Smith is taking this case vertical in this matter, Your Honor. There is a transcript we are waiting to get from the Judge Garcia's court, Your Honor, and it is going to be highly relevant to this matter. Both Ms. Smith and I had the opportunity to discuss this, and we both believe it's going to be something that would be very beneficial to not only ongoing negotiations with this case in itself.
Oh.
And just so the court's aware, it's related to a PPO hearing.
Okay, sounds good.
The same parties involved, similar parties involved.
Okay, and so Ms. Speck, you understand that you have the right to have a preliminary examination on this matter, in which you're charged with a child abuse third degree. You had the right to have that within 21 days of your arraignment. You understand that?
Yes, ma'am.
Okay, you were arraigned, it looks like back on December 15th, due to the fact that there is some pending discovery between the prosecution and the defense counsel. Are you willing to waive your 21-day timeline so that we can reset it?
Yes, ma'am.
Is anybody forcing you to waive that timeline today?
No,
Was there any promises made to you if you waive the timeline?
no.
Okay, I find your waiver to be made freely and voluntarily. I will get you a new date for your exam. You don't need another preliminary probable cause conference, do you?
I don't believe so, Your Honor.
February 3rd and 9th. February 3rd work for you.
Yes, Your Honor, that'd be perfect. Thank you.
Okay, we'll reset this for February 3rd at 9:30. Do you have any questions today, ma'am?
There is one, Your Honor, it should really take a brief moment. It's just related to the bond, Your Honor. There is an ongoing CPS matter that is also similarly related, or at least a collateral relation to this case. May I approach, Your Honor?
You may.
I got no doubt the court probably already has this, but it's just the bond condition, Your Honor, and it relates to this down here, a special condition where the court allows for visitation with Brayton, who is the named victim in this matter, but it must be supervised. And largely that's due so that CPS would be able to facilitate, supervise meetings between my client and her son. Apparently CPS is under the impression that the no contact order is absolute. And we're just, I don't even know what I'm asking for really, Your Honor, other than just reaffirming on the record, maybe CPS can watch this later, that she is allowed to have I'm sorry, not unsupervised. She's allowed to have supervised visits with her son. And that's, I'm just looking for that confirmation there, Your Honor.
Very clearly states may continue supervised contact with child as ordered by certain court.
As silly as that is, Your Honor, that's all we were looking for here, because there seems to be some miscommunication with CPS. They don't seem to understand that she can have supervised visits. They're essentially just preventing her.
That's interesting. It also states here on the notes when Magistrate Milmore, who arraigned Ms. Speck, defendant may have supervised visits with child initial BP as ordered by 30th Circuit. So it really shouldn't be an issue. I'm not sure what that's all about, but hopefully that clarifies it.
I hope so too, Your Honor. Thank you so much. Appreciate it.
No problem. Any additional matters for the record?
Nothing for the people. Thank you, Your Honor.
Not for the defense, Your Honor.
Okay, you're all set. Thank you. Thank you. Wow. Special business. Oh, yeah. Hopefully they notice.
Okay, I appreciate
All of this, all of
No,
this.
I asked them.
They need to. Okay, Ms. Donnelly, can I bring your client back from the breakout room?
Yes, Your Honor.
Okay, let's see what we have here.
Listen, I'll kind of give you that date.
On the record, in the matters of the people of the state of Michigan versus James Ryan Nicholas, I have two files, file number 22-00424 and 22-01514. Council appearances, please.
Brian Ring on behalf of people practicing under Michigan Court Rule 8.120.
And good morning, Your Honor. Stephen Milks on behalf of my client who is present via Zoom at this time, Mr. Nickel.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant in file 22-01514FY with the appearance of Mr. Nicholas being separately by Zoom from the Ingham County Jail.
Thank you. Today was the date and the time set for preliminary examinations on both matters. My understanding is that there is a request for an adjournment.
Your Honor, that is correct. Ms. Donnelly has been speaking with Mr. Nicholas extensively regarding possible entry into 55th District Court, sobriety court. This case has jumped around just a little bit, Your Honor. We did try to get him into 54B District Courts, drug court. But unfortunately, he was ineligible for that. But we do believe, and Ms. Donnelly, is my understanding, also believes that he should be eligible for the 55th District Court, sobriety court, Your Honor. So we just needed time to get him assessed.
This must be the return of the file from 54B. So he was at one point at least participating in the treatment court on file number ending in 424. Says that there was an order vacating treatment court and the file was transferred.
Correct. Before he had it is a little confusing and confused the heck out of me, Your Honor. He was transferred to 54B District Court before he pled and before they really took over the case, I guess. It was found that he was not going to be able to, I believe there was a failure to appear, Your Honor, but it was also just that he was not going to be eligible for the program.
Okay.
And so it just created a kind of a very difficult procedural issue there, Your Honor.
Okay,
But
so
we
we
believe
need to adjourn so you could be screened for additional treatment. Okay, sounds good. How much time do we need?
I can leave that to the Donald, Your Honor. I'm not as familiar with it. But
Your Honor, a typical, I believe I can get an answer within 30 days.
February 23rd. At February 23rd at 10 o'clock in the morning.
Thank you, Your Honor. Is that PE or PCC?
A PCC.
PCC.
Any additional matters on these files today?
Nothing from the people, Your Honor. Thank you.
Not from the defense, Your Honor.
Okay, we're all set. We'll see you on February 23rd.
Thank you, Your Honor.
Thank you. Okay, let's see. Looks like we got a few quarantines.
Oh, so.
Oh, wow. Is Stacy Spell in here? Or Halen? I don't see Mr. Nickel. Maybe his client didn't appear for sentencing. Does anybody know? Did Mr. Nickel's client appear for Halen?
I've seen Mr. Nickel, not the defendant.
Scott Nickel?
I haven't seen the defendant.
Okay,
For Scott Nickel?
I
yes.
saw him.
Saw him on the elevator.
I see Mr. Nickel. I just didn't know if his client appeared. I would
Or his
imagine he
client.
didn't. If Mr. Nickel's not here, we can get back to that one. I need Mr. Ring. I'm gonna take care of these 21-day waivers. We're on the record in the matter of the people of the state of Michigan versus Ronald Claggett, file number 22-03491, FY council appearance.
Brian Ring on behalf of people practicing under Michigan Court Rule 8.120.
And good morning again, Your Honor. Stephen Noakes on behalf of Ronald Leggett, who is not present at this time, Your Honor, and nor is he present over Zoom.
Okay, I do have a note here from the Ingham County Jail indicating that Mr. Claggett is in quarantine due to COVID-19 protocols. And so unable to be present today for his examination. He was arraigned back on December 15th. So I'm gonna find good cause to go beyond the 21-day timeline so I can reset that. Okay,
Yes, Your Honor. Thank you very much.
I'm sorry. You say
Are we doing the same thing as Josh?
we absolutely are.
I missed the date.
Oh, we didn't get it yet.
Oh, okay, sorry.
February 9th for both at 10 a.m. February 9th at 10 a.m. Any additional matters for the record on this file?
Nothing on behalf of people. Thank you, Your Honor.
And I'm sorry, is that the PE or PCC?
PCC, we already have PE. I mean, we already have PE, we already have PCC.
Oh, okay, yes, sorry, thank you very much.
On the 29th.
And nothing
Okay,
further from the defense.
very good. Joshua, James. Is that the one you're here
Yes, Your Honor.
for? Okay. On the record in the matter of the people of the state of Michigan versus Joshua James, file number 22-03507. Council appearance.
Brian Ring will be up to people practicing on Michigan Court Rule 8.120.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, standing in for Mr. Goodrich this morning on behalf of Mr. Jones, who's not present, Your Honor. I believe he's in quarantine. Yeah.
Correct, that's the information that the court was provided this morning due to the quarantine status and the defendant's inability to be present in the court. The court finds good cause to go beyond the 21-day timeline. Defendant was arraigned on this matter back on December 16th. We'll get a new date for February 9th at 10 a.m.
Thank you, Your Honor.
No problem. Any additional matters for the record?
Those are the people, thank you, Your Honor.
None on behalf of the defense, Your Honor. Thank you.
sir.
Have a good day, Judge.
Same to you.
Thank you so much.
Okay, let's see.
You have Carl Lindsay?
Do,
I'm covering for Crystal on that today.
she said she wanted an adjournment.
Just as that.
If she could get her, if I wasn't here, that's why she had me. She had a doctor's appointment pop up, so she was able to get in.
Right.
What did she tell you?
No, that's, I mean, it's just, that was the last I heard, was there was gonna be a adjournment, so that's what I was kind of. Let me, 'cause I think we still have my people here.
On the record in the matter of the people of the state of Michigan versus Zachary Clyde Johnson, file number 22-02870FY, council appearance.
Brian Ring on behalf of people practicing under Michigan Court Rule 8.120.
Good morning, Your Honor. John Abbott representing Mr. Johnson. He is present and standing to my right.
Okay, today is the date and the time that's set for a preliminary examination. My understanding is there's going to be a plea. I have a plea sheet here. It says the people are offering Mr. Johnson for you to plead guilty to an added count 2 of use of methamphetamine under MCL 333.7402A-A. That's a misdemeanor. Maximum penalty is 1 year and or $2,000 and fines. The people are moving to dismiss count 2 upon successful entry of your guilty plea, and there's no objection to sentencing under 7411 if you are otherwise eligible. Do you understand that to be your offer today, sir?
Yes, Your Honor.
Do you want to accept that offer?
Yes, I would, Your Honor.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Your Honor.
Okay, you can put your hand down. Mr. Johnson, you have the right to, in this matter, to proceed to a trial, and you have the right to a jury trial. At the time of trial, you have the right to be represented by counsel. You have the right to the presumption of innocence. You're innocent until proven guilty. You have the right to have the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You need to give up that right if you want to plead guilty today. Is that what you want to do?
Yes, Your Honor.
Okay. I have an advice of rights of plea information sheet. It has today's date on it. Is this your signature on here, sir?
Yes, Your Honor.
Did you read this document?
Can I read it?
Did you
Oh,
read it?
yes, I did.
Okay. And do you understand the rights that are on this document?
Yes, Your Honor.
You have any questions about these rights?
No, Your Honor.
Okay, so you understand that in order to enter your guilty plea today, you would need to give up your right to see, hear, or question any of the witnesses the prosecution intended to call against you?
Yes, Your Honor.
You're gonna give up the right to call your own witnesses or present evidence at trial that you believe would further defense of the charge?
Yes, Your Honor.
You're gonna give up your right to remain silent at trial and not have silence be used against you. You understand that? Anybody threatening you to get you to waive your rights and plead guilty today?
No, Your Honor.
Anybody making any promises to you in exchange for you entering a guilty plea?
No.
Are you currently on probation or parole? Are you on bond for any other matters?
No, Your Honor.
Do you understand that a guilty plea could result in a conviction that may have impact on any immigration status you may be seeking?
Yes, Your Honor.
You understand that a guilty plea could result in a conviction that you may need to report to either your current employer or to a future employer?
Yes, Your Honor.
And with that understanding, you still want to enter a guilty plea today?
Yes, Your Honor.
As to the added count 2 of use of methamphetamine, how do you plead?
I plead guilty, Your Honor.
Let's have a factual basis, please.
Thank you, Mr. Johnson. Thinking back to October 22nd of this year, were you at the Sparrow Hospital?
Yes, sir.
And that's right on Michigan Avenue here in the city of Lansing,
Yes, sir.
Ingham County, Michigan.
Yes, sir.
And at that time, you came into contact with the police
Yes, sir.
and got arrested for trespassing that day.
Yes, sir.
And when they arrested you, they found some methamphetamine in your possession,
Yeah.
and you've been using that. Yes. You had no prescription to use that.
No.
Okay. Nothing further, Your Honor.
Any questions from the prosecution?
Just one. Mr. Johnson, you knew that substance to be methamphetamine?
Yes.
No further questions, Your Honor. Thank you.
For the satisfied factual basis, I'll accept your plea. If I can you make freely, voluntarily, and intelligently. This matter will be set for sentencing. March 3rd. March 3rd at what time? March 3rd at 8:30 will be your sentencing date. You'll meet with probation so they can provide the court with a pre-sentence report and recommendation. You'll also have to undergo a substance abuse assessment. You understand that?
Say again?
You'll have to undergo a substance abuse assessment before you can be sentenced. Do you understand that?
Sure.
Okay. I have a PA 53 violation that you were arraigned on.
Huh?
I have a PA 53 violation, which is also known as a bond violation, that you were previously arraigned on that's not been addressed.
Okay.
Did we get a trespassing from this? This is from October. Looks like, yeah. You guys have a pending trespass? Not pending, but he did. I think we just handled that this week. Okay. I'll dismiss the PA 53 violation. Do you have any questions today, sir? Do you have any questions today?
No.
What's your address?
I don't have one.
Do you have a phone number?
No.
Any additional matters for the record?
Nothing to have people. Thank you, Your Honor.
Regarding bond, Your Honor, he's been in jail since October 22nd. And he's now changed from a felony to a misdemeanor. He's spoken to me that the address on the police sheet is 430 North Lark Street. That's the shelter address. He intends to go there. He's also been in contact with the people at CMH that will be assisting him in finding more stable housing. But
Justine.
so he's been in contact with Justine at CMH, and so I asked the court to reduce his bond to personal recognizance here, since it is now a misdemeanor, and get out there and work on finding more stable housing. As far as risk of flight, Your Honor, I think it's very low, and risk of harm to the community. The harm here is to himself, use of methamphetamine. I ask the court for personal recognizance. Thank you.
Turn I have is I just asked him what his address was. He didn't have one.
Which I think was honest. No- no-
601 North Larch is where he has got a trespassing from. What's the trespassing?
Where was he trespassed from?
He's got a trespassing from
Outreach in
the
the
outreach
hospital.
ministry. I'm sorry?
The outreach in the hospital has been trespassed,
So where's he gonna stay?
which there's 2 shelters.
I'm trying to see what the trespassing.
I'm having a hard time hearing. I got earwax in my ear. I'm sorry.
What address does it say? It says North Larch in the area.
Yeah, I'm just like-
Does it say an address of North Larch?
Really having a hard time hearing. Yes, so I'm able to go there. Yes.
The concern I have is that he has a trespassing. Did he get a heat pled? Is that what happened? He just pled guilty to a trespassing on North Larch. I don't know what address in North Larch that is.
It's 601 or something like that. There's two of them. There's two shelters on North Larch.
Correct.
Yes.
And you're saying the one that you pled guilty was for the one 601
Yeah, something like
and not
that.
430?
Yeah, not 430. No.
Okay. But we don't have a place or a way to send you mail?
430 North Larch.
You can't receive mail there.
Yes, I can.
No, you can't.
Why not?
Because they don't receive mail. They notified the court to stop sending mail there.
Serious?
I'm positive. They don't want mail from all the defendants that are staying
She's serious. I
there.
didn't know that. I didn't know that.
It's a shelter.
Huh?
Yeah, it's a shelter. They don't want to sort and find people who may be there or may not be there to give them their mail.
Well, I get mail from DHS there. and stuff.
I recognize that, but we can't
Just not
send
from the
mail.
courts, huh?
We can't send the mail. And so my concern is we release you and then you don't go and report to probation like you're supposed to have your pre-trial, your pre-sentence report done. You don't go and get your substance abuse assessment done, and then you don't show up for sentencing in March.
I'll do everything in my power to make that not happen. Your Honor. I've taken a huge I've done a lot of reflecting when I got faced with 5 years, and gonna try to I don't want to get into like my business or anything, but the whole methamphetamine thing is, I don't know. I'm gonna like work on that and stuff. And, like not work on it, I'm gonna stay clean, but I've done a lot of reflecting. I'm gonna take getting myself straightened out seriously. So that's all I have to say.
The risk of flight is high. He's missed court before. I'm not going to grant a personal recognizance bond, but I will reduce the bond. I think the bond is currently set at 1,000 cash surety. I reduce it to 1,000, 10%. You need to continue your services with CAT for mental health. You need to report to probation within 48 hours of your release. They can set you up for your pre-sentence report and investigation, okay?
So I have to sit in jail until March.
Or you can post a bond of 1,000, 10%. It's $100. Or you can post bond of 1,000, 10%. That's $100. Okay? Any other questions? Any additional matters for the record?
No, thank you.
Nothing appeal, thank you, Your Honor.
So wait, what am I sitting in jail for?
You're on bond. That's your bond pending your sentence. So you're sitting in jail for the same thing that you've been sitting in jail for. You have a pending charge.
Why do I have to wait until March?
You don't have to wait until March. You can post a bond, then you can get out.
But I can't afford that bond, Your
Well,
Honor.
that's not why I set bond based on how you can afford it. It's based on the risk of flight or your ability to return to court on your own recognizance or a threat to public safety. In this matter, I don't think there's an immediate threat to the public safety, but I do believe there's a risk of your inability to return on your own recognizance, okay?
So why is it such a long time? I don't have to wait till March. That's 2
Well,
months.
that's the date of your sentencing.
And then once I get sentenced, what is gonna happen?
Well, I don't know how you're gonna be sentenced yet. I can't tell you that. But you got up to 1 year in jail that you're looking at. Any other questions?
Well,
Thank you. I'm gonna assume Mr. Halen did not appear. I have not seen that.
No,
You said what?
no.
Are we running Barnes?
We will be, Your Honor. I'm good. I was heading out there to check to see if my victim was here.
Oh, it is not, it's just not my.
She has previously shown up before.
Full bench warrants to Halen. Okay, we have one more person in quarantine, that's at one.
Here again, let's get this dismissed again.
What's going
Good morning, Your Honor.
on? Good morning. Oh, those are pieces. We're on the record in the matter of the people of the state of Michigan versus Luke Andrew Major, file number 22-03522. FY, council appearance.
Brian Ring on behalf of people practicing in Michigan Court Rule 8.120.
And good morning, again, Your Honor, Steve Mills on behalf of Mr. Major, who is present and staying for the right at this time.
How are you, Mr. Major?
Fine, thank you.
Today's the date and the time set for preliminary examination on one count of controlled substance possession. My understanding is that there's going to be unconditional waiver to the circuit court, is that correct?
That is my understanding, Your Honor.
Yes, that is correct, Your Honor. He does have a pending case in circuit court, so we're looking to do a rule resolution. Most likely, we are going to be getting assessed for the drug court.
Okay. Okay, Mr. Major, you understand that you have the right to have a preliminary examination on this matter here in the district court?
Sure.
You understand that the purpose of the preliminary examination is for the prosecution to meet their burden of probable cause. So they would need to establish today that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. Do you understand that?
Yes, Your Honor.
You're willing to unconditionally waive that examination today?
Yes, Your Honor.
You understand that unconditional, I mean, you can't come back later and say you want to have your exam?
Yes, Your Honor.
Anybody threatening you to get you to waive your exam today?
No, ma'am.
Any promises being made to you in exchange for waiving your examination?
No, Your Honor.
That's your signature on this document here?
Yes, ma'am.
Okay. I find your waiver to be made freely and voluntarily. The matter will be bound over to the circuit court for a bind over date of January 18, 2023. You do not need to appear in court on January 18th, okay? That's the date they get the file from this court. Your next court date will be in circuit court. It will be a pre-trial. You and your attorney will be notified of that date, okay?
Sure.
We do not have an address. Is that still accurate,
No.
correct? Yes, okay. We do have a phone number ending in 4449. Okay. Do you have any questions at this time, sir?
No, Your Honor.
Bond was originally set at $500 cash surety. That will continue. Any additional matters for the record?
Nothing from the people. Thank you, Your Honor.
None from the defense, thank you.
You're all set.
Your Honor, I think we handled Carl Lindsay. Yeah, so you're after.
We're on the record in the matter of the people of the state of Michigan versus Carl Lindsay, file number 22-03520 FY. Council appearance.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people. I'm covering for Kristen Murphy today.
And good morning again, Your Honor. Stephen Milks on behalf of Mr. Lindsay, who is present and staying to my right at this time.
Okay, how are you, Mr. Lindsay?
How you doing today, Your Honor?
I'm doing well. Today was the date and the time set for a preliminary examination on this file. Looks like there's also a PA 53 violation. Looks like it was because your GPS tether was cut off. Did you get that taken care of? That was
Yes.
in December.
No, the last time I came to court, they said I didn't pay the tether, but it was paid. I haven't missed a payment or anything like that.
He has the tether on now, Your Honor.
I have to tell you.
At the PCC, Judge Ward brought it back. I think there was a warrant.
Yeah, it looks like the 22nd, we received notification that he would be shut off on the 27th for non-payment. he appeared, it looks like, on the 29th. So he must have paid before that date, the shut off date.
He did, Your Honor, and he's got the tether on right now.
Okay, how are we proceeding on the underlying matter?
We're going to be asking for an adjournment today. And I have spoken with defense counsel, and I believe that it's going to be stipulated too.
Is that correct?
That is correct, Your Honor, and I would just like to say, Ms. Murphy was originally on this, last minute things changed, I don't know if they're outside of her control. Mr. Pfeiffer has come in and in a true offer of good faith, Your Honor. He's understood that, the last email I had was that we were gonna be expecting an adjournment because of Ms. Murphy's absence. So I just want to say, I think that's, shows a lot of character there, I appreciate that. We're also hoping to have Officer Rotuno here. My understanding is due to a good personal matter, he's not able to be here today.
Okay, just so I'm clear, the issue is that the prosecutor is not available?
Yes, Your Honor. Chris Murphy is not available today. Her communications with me are going to be running the exam. I had an officer here, not Officer Tuno, whose wife is giving birth today. Her last communications with Mr. Milks was an adjournment, and a miscommunication shouldn't end up as a rug pull for the defense, which is effectively what would be happening. They were prepared for an adjournment. It was what they were expecting for good reason. It would not be proper to go through with it today. I discussed that with Mr. Milks.
Okay, sounds good. Okay, and did you advise your client of his right to have the examination within 21 days of his arraignment?
I did, Your Honor, yes.
Okay, and so you understand that right, sir?
Yes, ma'am.
Are you willing to waive the 21 days today so they can be reset?
Yes.
Anybody threatening you to get you to waive that timeline?
No, Your Honor.
Okay, and any promises being made to you in exchange for you waiving your timeline?
No, no, no.
Okay, we'll get you a new date. You said that the officer has a child due?
Yes, Your Honor.
Okay, is he going on leave?
I do not know, Your Honor.
Is he here?
No, Officer Tuno is not here. The people prepared to proceed with Officer Schaefer. But based on my conversation with Mr. Milks today, that Officer Tuno is one that Mr. Milks would like to have here for cross-examination.
I not thought of that, Your Honor, great point. I'll talk to Ms. Murphy and we'll continue our conversations if something comes up.
Okay, sounds good.
Thank you.
Either way, the people prepared to proceed and achieve bind over solely an officer testimony under 27C.
February 10th at 9:30. February 10th at 9:30. Any additional matters for the record today?
Not from the people, Your Honor.
Your Honor, I'm sorry, my client would like to just bring up regarding his bond. He does have the tether on. It is creating a financial hardship for him, just to the court where he's got a $30,000 cash surety bond. The house was put up. He has no interest in seeing the complaining witness in this matter. He has no interest in obviously forfeiting a house that was put up for bond, Your Honor. But with all these costs and everything, the GPS tether is becoming a significant burden. We're wondering if the court would consider removing that.
Your Honor, people would object to that motion. I ask that you deny it. These are very serious charges, including accusations of the defendant stopping the victim from calling police and working to stop the victim from getting help. In addition, the violent felonies of strangulation. I believe that the GPS tether is appropriate and necessary in such a case.
I don't know anything more significant than losing one's house when it comes to bond at this point. It's far too great a burden.
People have risked all kinds of things. And ended up in jail, so I don't know if that's a argument I'm gonna rely on. I'm gonna continue bond as is. So your motion to amend bond is denied. Any additional matters for the record?
Not from people.
Nothing, thanks, Your Honor, thank you.
Thank you.
Barnes.
I will go, I just didn't know.
Yeah, no problem.
You know what happened to Mr. Ray?
I'm going to go get him. I believe he's talking with the victim at the moment.
Okay.
Barnes. Prosecutor. Getting. No. Talking to the victim. Not, no, he was talking. So,
I'll let him know the Barnes case is ready. He's finishing up his conversation with him. Yes. Every time I try and leave, Brian, you pull me back in.
Barnes.
Maybe we approach Your Honor?
Come on up. Go on the record in the matter of the people of the state of Michigan versus Patrick Gordon Barnes, file number 22-03063, FY, counsel appearance.
Brian Ring on behalf of people practicing under Michigan Court Rule 8.120.
Morning, Your Honor. Jeff Chip on behalf of the defendant, who is here and standing to my right.
Thank you. Today was the date set for a preliminary examination. There's also a PA 53 violation. My understanding is there was a plea offer. Is that correct?
That's correct, Your Honor.
Oh, I have a plea sheet here. It says the people are offering for the defendant to plead no contest to count 2 of domestic violence first and added count 3 domestic violence first, and that they would dismiss. How,
Count one, I apologize, Your Honor, if that wasn't clear.
okay, Killebrew of no upfront jail, is that the offer?
That is correct, Your Honor. And also there's a bond violation hearing today, and prosecutors agreed not to pursue that alleged violation of bond.
Bond violations of contempt of court, you don't have to pursue it.
Oh, okay. Well, then, whatever the court would like to do on that, we're hoping that we can.
What's the purpose of the no contest plea?
Possible civil liability.
Possible civil liability, or is there some damage to something or injury?
There's no injury that had any medical
Okay,
treatment that I'm aware of.
so I'm not understanding the possibility of civil liability.
Well, a person could make a claim for an assault and battery type of civil case without a documented injury.
Okay, but I want to know why in this particular case, there's a reason for a no contest plea, because at this point, I don't think it's appropriate. I'm not getting enough information to deem that, just based on the fact that there was an assault. If that's the case, then we could get everybody a no contest plea anytime there was assault of crime.
All right, can I have a minute, Your Honor?
Absolutely.
Thank you. We'll do that. All right. We'll plead guilty, Your Honor.
Oh. Mr. Barnes, that's what you want to do today? You want to plead guilty to the count 2 of domestic violence first and the added count 3 of domestic violence first?
Yes.
Okay, I have a advice of rights and plea information sheet with today's date on it. Is that your signature?
That is.
Okay, you read this document?
I did. Okay.
Okay, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
That is.
Okay, you can put your hand down, sir. You have the right in this matter to proceed to trial. At the time of trial, you have the right to the presumption of innocence, so you're innocent until proven guilty. Do you understand that?
Yes, I do.
You understand that you have the right to have the prosecution meet their burden of proving each element of the charges being brought against you. They have to prove each element beyond a reasonable doubt.
Yes, I understand.
You understand that you're giving up those rights today if you enter a guilty plea?
That is correct.
Are you willing to give those rights up?
That is correct.
Okay, you also understand that you're gonna give up the right to cross-examine any of their witnesses. That includes the alleged victim and any other witnesses they intended to call. You understand that?
That is correct.
So you're gonna give up the right to call your own witnesses or present evidence that you believe would further defense to these charges. You understand that?
Yes, I do.
Okay, you're gonna also give up your right to remain silent, not have silence be used against you. You understand that?
Yes, I do.
You understand that a guilty plea can result in a conviction that you may need to report to your current employer, or you may need to put a criminal conviction on future job applications. You understand that?
Yes.
You also understand that both of these counts are misdemeanors that are punishable with the maximum penalty of 93 days in jail and or $500 in fines. Okay, and there is a killable agreement. That's an agreement between you and the prosecutor about how you want to be sentenced or how you should be sentenced. And that's to no upfront jail, but I'm not a party to that. So I'm not agreeing to not sentence you to jail. You understand that?
Yes, I do.
So you understand that at the time of sentencing, if I decide that I am going to sentence you to jail and you are facing up to 93 days, I would then give you the opportunity to withdraw your plea. Do you understand that?
Yes.
Okay, and also, do you understand that a guilty plea could result in a conviction that may have impact on any immigration or travel status that you may be seeking? Like you may want to go to Canada and a conviction could prevent that. You understand that?
Yeah.
Oh, and you still want to waive all those rights here today?
Correct.
Are you currently on probation, parole, or on bond?
No.
Okay. As to the added count, I'm sorry, as to the count one of domestic violence, how do you plead?
Guilty.
You sure?
Yes.
Okay, as to the added count three of domestic violence first, how do you plead?
Guilty.
Have a factual basis on both.
Thank you, Your Honor, if I may. Mr. Barnes, on August 18th, 2022, were you in the city of Lansing? Yes. County of Ingham? Correct. State of Michigan? Correct. Okay, and on that date and time, did you come in contact with a Miss Bennett? Yes. Okay. Did an altercation take place with Miss Bennett in which some pushing and shoving took place? Correct. And that altercation that took place resulted in you pushing and shoving Miss Bennett on a couple of different occasions, although it may have taken place at the same set of circumstances. The physical contact may have happened on more than one incident of touching. Is that a fair statement? Did you touch her more than twice when this altercation took place? Yes. Yeah. No further questions. Thank you, Your Honor.
Any questions from the prosecution?
And I just want to clarify, was that on the 17th of August or the 18th of August?
So that may have been the 17th late night. But would it be fair to say that was late night 17th? Correct. Okay, sorry.
And did that occur at 1019 Clark Street?
Correct.
No further questions, Your Honor. Thank you.
That's in the city of Lansing, Ingham County, state of Michigan.
That is correct.
Okay, the court is satisfied with the factual basis. I'll accept your plea. Find your plea may plead voluntarily and intelligently. This matter is set for sentencing on March 3rd, 2023 at 8:30 in the morning. We'll get you a copy of your notice to appear for that date. I'll dismiss the contempt for bond violation that was set for today. My understanding that there was a victim here today. Is that what it was?
There is, Your Honor, that is correct.
Okay, and the concern was that the victim wanted to make a statement. The victim can appear at the time of sentencing via Zoom if that's what they want to do.
No, that's correct, Your Honor. Defense counsel just asked if you would be open to sentencing today, and I just will let the court know that the victim was here in case that was an option, Your Honor.
Okay, no, I'm not moving to immediate sentencing on 2 DV charges. He's going to report to probation today when he leaves here so that they can provide the court with a pre-sentence report and an investigation and advise the court how he should be sentenced and what, if any, programming is necessary. Sentencing can be held via Zoom, if all parties consent to that.
I consent to that, Your Honor.
As do I, Your Honor.
Okay, very good. Do you have any questions today, Mr. Barnes?
I think you are clear.
Okay, very good. Any additional matters for the record, counsel?
Just one, Your Honor, I would just ask that you reiterate the no contact order to Mr. Barnes in light of the dismissed PA 53 violation, in light of the victim allowing the no contact order to be reduced from that 1,500 feet to the 500 feet so that he could return to his home. I would just ask that you reiterate that for him.
Okay, well, we're gonna reiterate it. We're gonna remind you that there's a no contact order. I am dismissing the contempt order. It was from December 15th. There was an allegation. The allegation appears to indicate that the victim perceived you have to have been maybe stalking or driving by in an attempt to intimidate. There's a no contact order. I understand you all live in close proximity to one another. So there's no way for the court to prevent you from driving past the alleged victim or the victim at this point. But there shouldn't be any reports to the court that you rolled your window down and you were staring and doing anything that could be perceived as intimidation. Do you understand that?
Yes, I do.
You don't want that.
No, I
You
don't.
definitely don't want that before your sentencing date either. You understand that?
Yes, I do.
Okay. A no contact order will continue and we will see you on the date of your sentence. Any additional matters for the record?
Nothing else for the field. Thank you, Your Honor.
Nothing for the defendant, Your Honor. Thank you.
Thank you. Mr. Cage, your turn.
Oh, you gave him his paperwork?
Yeah, I'm gonna take him on probation. So.
Sounds good. Thank you. No, you're good.